I'm Jim Acker. I'm an emeritus professor at the University at Albany. I want to welcome Maurice Chammah to the New York State Writers Institute for this discussion about a marvelous book that he has authored, Let the Lord Sort Them: The Rise and Fall of the Death Penalty. Maurice is a former Fulbright Fellow. He's a journalist and a staff member at the Marshall Project, which is an organization that does terrific investigative work and reporting on criminal justice issues. Maurice has published extensively in a number of outlets, including The New Yorker, The Atlantic, Mother Jones, Esquire, The New York Times, other venues. He and his wife, Emily, have organized an essay writing competition for incarcerated individuals called the Insider Project. So Maurice, welcome. It's very good to be able to talk with you about your book.
Thank you so much for having me. I'm really happy to be here.
As we talk about Let the Lord Sort Them, I just want to alert viewers that the book is available at the link that's going to be visible at the bottom of the screen at local independent outlets. So it's a recently published 2021 book, well worth perusing. It's a book that focuses largely on the death penalty in the state of Texas. And it's something of a marvelous tapestry that intertwines individual stories and reports of individual cases, but embeds them in larger themes about capital punishment. And I'd like to start with talking about the rise of the death penalty in Texas and follow up on this theme of how individuals that you focus on in the book do kind of highlight broader themes. One of the people that figures prominently in the book is Dana Lynn Reeser. And with respect to the very long history, or at least part of it, of capital punishment in Texas, Ms. Reeser's master's thesis kind of led her to develop a theory about some of the origins of the death penalty in Texas, and then led to her later involvement. So can you kind of take up how she kind of piggybacked this master's thesis into a career that illuminated issues about the Texas death penalty?
Absolutely. So Dana Lynn Reeser was somebody who I met fairly early on in my research on the death penalty, and she is not a particularly well-known capital defense lawyer. She had been kind of working quietly in this very, in some ways, sort of insular world of death penalty defense lawyers who primarily fight death sentences at the very end of the process, which is to say right before the execution. They're the ones filing all of the last minute motions and briefs to try to stop executions, who often investigate cases in a way that they've never been investigated before and find out that there's tremendous problems with the cases. And then they make arguments to the courts about why an execution should be stopped. And I wanted readers to get into that world, partially because in this day and age, in 2021, some lawyers who do this work are sort of heralded as heroes. People like Brian Stevenson is very famous now. He runs a nonprofit in Alabama called the Equal Justice Initiative and has a whole memorial towards lynching and a museum that kind of explores this connection between lynching and the death penalty. But there was a time when these defense lawyers like Stevenson and like Dana Lynn Reeser were sort of societal outcasts, in the sense that they were seen as these unscrupulous lawyers who would defend the worst of the worst and try to keep society from being able to punish these death row prisoners in the way that society wanted to. And I wanted to dive deep into that moment in history and what it was like for those lawyers, because I thought it would speak to our contemporary moment in an interesting way. And I came to focus on Dana Lynn Reeser primarily because she was the most outspoken and clear among the Texas lawyers, because the focus of the book was Texas, on the connection between the contemporary death penalty and the history of lynchings. And by this, I mean that, in the late 19th and early 20th century, America, and especially the South, saw basically an epidemic of mob killings of people who were accused of crimes, not necessarily convicted of them. Often these were Black men. Often the crime that they were accused of was rape, or the rape, and particularly the rape of a white woman. And Dana Lynn Reeser, she was an undergraduate at the University of Texas in the early 90s, and then she began a master's program, and she was fascinated by this history of lynching because it had so much to do with the stories that society was telling itself at the time about who is evil and who is dangerous and who needs to be cast out from society. Almost like in Shirley Jackson's story, as the problem in society. And that came, primarily to focus on Black men in the aftermath of the Civil War and Reconstruction, and the assertion by Black Americans, right, of their rights to citizenship. So Dana Lynn Reeser does this research, and her research kind of starts to creep forward out of the past. I was fascinated by how she went from doing sort of pure historical research to seeing connections to the present at the time, of course, being the early 90s. And around this time, she gets a phone call from a group of capital defense lawyers, death penalty defense lawyers, called the Texas Resource Center. They have this very vague name because they don't want the public to fully know what they do. They would otherwise get, death threats and such. And Dana Lynn they contact her about her research. She ends up going to their office. She falls into volunteering for them. She's a woman in her 20s, and there's a lot to do. And she starts to see that the lynchings that happened 100 years ago and the death penalty in the present, in her mind, are not so different. And I think that historical continuity was very clear and formative for lots of defense lawyers in that era. And now it's something that we as the public understand a little more clearly. The book, obviously, itself is an effort to advance that understanding of the links between our contemporary criminal justice policies and our very sort of unresolved history of racism in America. And so Dana Lynn Reeser, I thought, was a sort of compelling individual to take readers in, because even if you couldn't identify with everything about the way she thinks, you could kind of follow her in her intellectual journey as a young woman, seeing what role she could play as a white woman fighting what she thought of as racial injustice in our society. And the death penalty became the focal point for her.
Well, that link between racial discrimination and bias and lynching and capital punishment, of course, is not unique to Texas. And you make the point in the book that in the 1960s, the NAACP Legal Defense Fund mounted waged legal war against capital punishment, and it was in large part because of the racial dimension of the death penalty. Could you take us up to the Legal Defense Fund's kind of challenges to the death penalty that kind of spanned the early 60s and culminated in 1972 with Furman versus Georgia and a case from Texas, Branch versus Texas?
Sure. So the Legal Defense Fund, which was an outgrowth of the NAACP, they had originally been part of the organization but had split off. It's a civil rights firm that I think is most associated with Thurgood Marshall, who went on to the Supreme Court. After Thurgood Marshall left the organization, there were a lot of very seasoned civil rights lawyers there who intimately understood that there was a link between the death penalty and lynching, much as Dana Lynn Reeser would, 30 years later. And they saw the death penalty as a tool of racial repression, and they wanted to fight it on that front. But that is to say, there were plenty of white defendants who also got the death penalty, and so the Legal Defense Fund started to edge out of only focusing on cases of Black defendants and expanded their work because they felt like the entire policy of the death penalty needed to be fought and eventually abolished. And as lawyers, they went about this in a legal way. In the 1960s, they wrote up what were called last aid kits, which were collections essentially of briefs, of motions that lawyers could use to stop a death sentence, even if they didn't have much expertise in that area of the law. And they took on the cases of many men who were facing execution throughout the country, and vociferously objected to these executions in courts. And they managed to not end the death penalty, but to slow it down. And so the number of executions in America year by year in the 1960s started to slow down, and eventually it stopped. At the time, the Supreme Court was also more liberal, more interested in the rights of criminal defendants. This was the era of cases like Miranda versus Arizona and Mapp versus Ohio that really entrenched the legal rights of people facing accusations of crimes. And these LDF lawyers eventually get to a point where the Supreme Court agrees to hear a singular challenge to the death penalty system in America. They join a group of cases, 2 from Georgia, 1 from Texas, all under the banner of a Georgia case called Furman versus Georgia. And listening back to that oral argument now, you can see that there's a real focus on race. There's a quote where Anthony Amsterdam, the lawyer arguing on the LDF's behalf, says, the quote, the figures are perfectly plain, Georgia executes Black people, right? And he's making this kind of very muscular rhetorical point. The Supreme Court, somewhat shockingly, agrees with the LDF that the death penalty system is unconstitutional, but in their opinions about it, they de-emphasize race for the most part. Thurgood Marshall is there, and he understands the role of race fairly well, but many of the others on the Supreme Court don't want to talk so much about Black defendants and white defendants. They more decide that the death penalty is unconstitutional because it's arbitrary. And one justice on the court compares it to being struck by lightning, that whether you get a death penalty or not has really very little to do with how heinous the crime was or whether you have a past history of crime. It's just this random lightning strike that has more to do with the vagaries of how your case plays out, who your lawyer is, et cetera. So this is a monumental decision, and part of what's so monumental about it is the backlash that it invites. So where around this time, many other countries in the world that are kind of politically comparable to the US, Western Europe, Canada, Australia, are abolishing the death penalty. The United States seems to follow suit, but then we take a turn and there's a backlash. And because the Supreme Court has left the door open that the death penalty could be constitutional if new laws are written, this invites many American states to go and write their laws. And what we see in every state, I decided to focus on Texas for various reasons, but state legislatures have this sort of internal debate about what kind of law is going to satisfy the Supreme Court. And in the end, in 1976, the Supreme Court approves.
Don't jump ahead to 76.
Oh, sure, go ahead. We can stay on 72 for a moment.
One of the fascinating aspects that you develop in the book to me is, so in 1972, death penalty laws across the country are ruled unconstitutional because, as you said, there's too great of a risk that sentences of this degree of importance, death, life, are imposed in an arbitrary way, maybe infected with impermissible reasons. So Texas, like most states, up to 1972, had a single trial where you're charged with murder, or in Texas, some kinds of rape, maybe, and the jury would say guilty or innocence and come back, if guilty, death or life. Now, when the death penalty law like that is wiped out, the Texas legislature, like elsewhere in the country, has to make 2 decisions. Should the death penalty be resuscitated? And if so, and here's the tough one, I mean, they're both tough, for what crimes, for what people, and how will it be decided? And the story you tell in here about how the Texas statute arrived in a unique form, which I hope you can describe a bit, is just amazing, given how Texas has been head and shoulders above any other state in using the death penalty. So take us to 1973, if you will, and
Sure.
what's going
Absolutely.
on in those legislative halls.
Absolutely. So, when I started researching the death penalty, I assumed that the story of why Texas was the epicenter of the death penalty over the last, 40 years was going to be mainly a story about our culture, our history, sort of some big, broad, sweeping things. And those elements are there, and I explore them in the book. But there's also a very sort of particular and technical story of the law that the Texas legislature passed in 1973 and the way that that law shaped our death penalty system to be one that in many ways smoothed the path to death row for a lot of defendants. So in 1972, the Supreme Court, as I've said, strikes down the death penalty laws around the country, and every state has to decide whether or not to bring back the death penalty. In Texas, it's somewhat of a foregone conclusion. I managed to interview quite a few of the legislators from that era. I was sort of just lucky by the historical quirk that many of them were elected at a very young age that year. A lot of them were in their 30s, even their 20s, and so they were sort of still alive and able to talk about the experience now. And um, many of them, all of those who supported the death penalty said, "Oh, of course we had to bring it back. All of my constituents supported it." There was a phenomenon where death penalty support throughout the country had been dipping in the 60s as the number of executions went down. But then after the Supreme Court deprived Americans of the death penalty, support for it spikes again. And there's a sense that we didn't realize we missed it until we didn't have it anymore. Um, and the legislators who opposed the death penalty, there were a few of them, primarily liberal legislators from Houston, really seemed to have no rosy-eyed glasses about their ability to succeed in keeping it from coming back. That this train was coming down, and they were going to have to confront it. But the decisions that these legislators have to make about the new death penalty system, there's sort of two models out there that states are considering. One model is something more like what had existed before, which is to say the death penalty is going to be automatic for certain crimes. We're going to pick a very specific set of crimes, whether it's the murder of a police officer or murder in the course of a rape. And the second the defendant is found guilty, that's going to be the end of it, and they're going to go to death row, and that's it. The other model that states come up with is more complex. It's that there's going to be essentially a second trial, a sort of second hearing. The term that gets thrown around is a bifurcated trial, where you have the guilt-innocence portion and the sentencing portion. And in the sentencing portion, after someone is found guilty, the jury is going to hear the prosecutors and the defense lawyers make arguments about whether this person deserves the death penalty. Prosecutors are going to tend to focus on how heinous the crime was, their prior history of crime, and maybe a psychological profile of them done by an expert. The defense is going to bring in mitigating factors, the fact that maybe this is their first crime, or that they have a loving family who thinks that who really relies on them, or that they have severe mental illness that really impeded their ability to understand what they were doing, and the fact that they committed this murder should not be, they shouldn't be seen as nearly as culpable as someone else. And that system is chosen by many states. Texas is almost alone. Oregon eventually ends up copying us, but Texas comes up with this third style that's sort of in between the two. And on the one hand, there is a second hearing over whether someone deserves the death penalty, but there's a much, much more limited sense of what the jury is allowed to decide on. And they come up with three questions. I should say first that the Texas House and the Texas Senate, the two chambers of our legislature, had sort of been debating these two different versions of the law and couldn't come up with a way that they thought would pass the Supreme Court's decision making. And they, time started to tick out. Texas legislature meets every other year and only for a few months, and there was the sense that time was running out and they had to pass a law. So over a weekend in May of 1973, they hash out basically a compromise between these two visions that pretty much everyone involved admits now was an idea that was sort of rushed and maybe not so thought out. And it's this third way where there's a second hearing, like I've said, but the jury just has to answer three questions. Was the crime deliberate? Was it a response to a provocation, like a sort of self-defense? And for the most part, those two questions are pretty much assumed with the guilty verdict. It's hard to get to it, a capital murder conviction, without those being folded in. So really, those questions are pushed to the side, and the seminal central question is this person going to be dangerous in the future? Do they present a continuing threat to society? And at the time that the legislature passes that law, the legislators really don't even agree with one another about what it's going to mean. Some think that it favors the defense, some think it favors the prosecution, some think it's just very fair and down the middle. But what ends up happening is the Supreme Court approves of that law, and that forms really the next 40 years, with Texas being the center of the death penalty.
And as you describe in the book, one of the cases that made it to the Supreme Court in 1976 came from Texas, the Jurek case. And you report that there's something of a conundrum that's confronted by the litigators in terms of whether to go after the death penalty in and of itself, as opposed to taking a more refined, particular look at the Texas statute. And I think you talk about the conflict between cause lawyering and individual case, and that also is quite interesting. Can you kind of explain what that debate was about and how it was resolved?
Sure. So, the LDF was, by this point in the mid 70s, having gone through, fighting the death penalty throughout the 1960s, were really the clearinghouse for anti-death penalty defense lawyering in America. They were considered the experts on the subject. Their lawyers had argued at the Supreme Court multiple times, so the justices knew these lawyers and really kind of maybe didn't always agree with them, but trusted their credibility and their expertise. And the LDF believed that the death penalty should be wiped out for good. And that meant that they needed to argue that all of the different state laws were unconstitutional, that no state law could possibly create a system in which people were sentenced to death in a just way, that it was an impossible thing to do. At the same time, the way that our legal system works is that we don't necessarily debate these laws in courtrooms in the abstract. We debate them through the vehicle of individual cases, right? So Roe v. Wade, these famous cases, there's real people's names attached to them, and real people are the clients on both sides. And in the case of the death penalty, that meant that there were men sitting on death row, and the outcomes of these death penalty cases at the Supreme Court didn't just affect the laws as they were written in these states. It affected whether these primarily men, and in some cases women, were going to be killed. So, of course, their interests might actually come into some conflict with the overall strategy, by which I mean, for example, in Texas, this law looked extremely harsh when compared to the more sort of open-minded laws that allowed for a really robust understanding of mitigating circumstances or aggravating circumstances around the crime. And if you're the death row prisoner in Texas, in the actual case, it was a man named Jerry Jurek, your life depends on the way that this case goes. And you may not really care about what happens to death row prisoners in another state. The LDF cares about all of them. But for you, the best argument may just be the Texas law is too harsh. It is too much like those other laws that make the death penalty mandatory. It doesn't allow the jury to really look at the circumstances of the crime or the defendant and consider extending mercy to them. This whole focus on future dangerousness is too simplistic and is problematic and is going to lead to arbitrary outcomes. So that would have perhaps been the argument if you are just arguing against the Texas law. But of course, the attorneys at the NAACP Legal Defense Fund didn't have the option of trying to draw these fine-grained distinctions between the laws, because if they were to say that some laws were okay and others weren't, then they would be essentially consigning to execution the men on death row in the states where the laws were considered acceptable, right? So they couldn't, they didn't want to throw certain prisoners under the bus in order to save other prisoners. And of course, they're making this decision in a very fraught moment where they have the possibility of winning everything, of getting the entire death penalty thrown out again, of getting the Supreme Court to say all of these laws around the country are problematic. And given that that's an option, it seems sort of impossible for them to take, half a loaf, and I'm using a lot of metaphors, and I'm not sure why, but to win, only go for a smaller victory, thereby imperiling all of these other men on death row. And so, because they are driven by the cause of opposing the entire death penalty rather than just looking out for the particular interests of each of these clients in isolation, they have to make the wide-ranging argument that the entire death penalty system as it exists now is problematic. And they claim that there's too much human discretion essentially in the system, that there's too much human decision-making, and that you can't make a system given these human decisions in which you're not going to get somewhat arbitrary outcomes.
As it turned out, as you described, the Supreme Court, several years after 1976, I think it was 1989, did agree that the way the Texas law was crafted did not allow enough leeway for consideration of mitigation evidence. Is that right?
That's right. It was in 1989, and it was a case where the defendant's name was Penry. And this is many years later, and unlike in that 1976 case, Penry's lawyers are just representing Johnny Paul Penry, and but they are making an argument about the Texas death penalty law, and they're saying that this emphasis on future dangerousness and the lack of other questions, they conflict with the Constitution's guarantee that you get, a fair trial, and specifically, there's a kind of growing body of jurisprudence that says that in death penalty cases, you are entitled to what's called individualized sentencing. That we're not just going to say everybody who commits this one crime gets the death penalty, but that each individual person who's facing the death penalty gets a sentence that is at least individualized to their particular history and self, right? And that opens the door to defense lawyers bringing in all kinds of arguments as to why somebody should be offered mercy by the court, by the jury. The Texas legislature is forced by this 1989 decision to go back and rewrite the law again, and they maintain the emphasis on future dangerousness, but they add a question that is, are there any mitigating circumstances that would allow this person to not go to death row? And it's an interesting juxtaposition to 1976 because they're only defending Johnny Paul Penry, and so that's how they can convince the court of that argument. But I also think that there's a lot of defense lawyers who feel like there was a 13-year period, or even really a 16-year period when you go back to the writing of the law, 1973 to 1989, in which hundreds of men were sentenced to death under this flawed statute, and it was not retroactive, so they stayed on death row.
This area of mitigation evidence is fascinating, and particularly in Texas. But you point out that there is a tension, I think, between what the court ruled in 1972, that there's too much arbitrariness. We need more consistency in the application of the death penalty. And you juxtapose that with the requirement now that individualized consideration be given to each and every case, which to some degree would be, at least on the surface, not consistent with the non-arbitrariness theme. On the one hand, it ought to be consistent. On the other hand, we got to go case by case. But I'd like your thoughts on that. But also in Texas, to me, it's mind-boggling to ask a jury that has concluded, yes, I think this person's going to be dangerous in the future, but there is reason, nevertheless, to mitigate the punishment. I mean, how do you resolve it? I mean, if you can tackle any of this, it would be
Or,
interesting.
I mean, a part of what I think I found so fascinating about this research and what I think has compelled me to the death penalty even more than other criminal justice subjects over the years is the way it raises up philosophical conundrums that go even deeper than the criminal justice system. It starts to, in the trial transcripts, I started seeing prosecutors use words like evil to describe defendants. And that is like a legal term and more a theological one. And I was sort of fascinated by that. On the subject of these early 1970s Supreme Court decisions that would seem to kind of cut against each other in terms of individualized sentencing, but wanting everyone to get an individualized sentence, but then not wanting the outcomes to seem arbitrary and very person specific. I was trying to sort of understand that, and I ended up really relying a lot on the analysis of a scholar named Evan Mandery, who wrote his own very good book called A Wild Justice about a series of Supreme Court cases in the 70s. And he very elegantly formulated it as a person cannot be both unique and equal, which is to say, if the legal system is trying to treat each person individually, then it's naturally going to cut against the desire to grant a kind of equality to all people in the way that they are treated. And this sounds very abstract, but in actuality, the way it plays out in case after case is that individual people, how shall I put this? We give prosecutors, we give juries, we give judges all of this leeway to make decisions, and then we're somehow surprised when we are troubled by the outcomes, whether it's racial disparities or a tendency to sentence people with mental illness to death or something. That we, the more individualized decisions we have, the more sort of the implicit biases that we have as a society and as individuals are going to start to show up in the aggregate, right? And so casting aside the question of whether these individual cases are arbitrary, you're going to start to see racial disparities sort of foremost among many other examples. And I think that this is a tension that exists in all criminal cases. This is not unique to the death penalty. This exists throughout the entire criminal justice system, from misdemeanors up through felonies. The problem is that we also have decided that we think the death penalty is special. I mean, the phrase that is in the book quite a bit, because it's used by lawyers in these earlier eras, is death is different. This idea that death is just a different category of punishment. And so we need a better system for doling it out. But I found over and over again that it's very hard to disentangle the death penalty from all these other problems that we're sort of, as a society, may not think are great, but are willing to tolerate when it's a question of how we punish misdemeanors or even how we punish fairly serious felonies. They're sort of we don't support racial disparities, but we are a little bit more willing to kind of experiment moment by moment to try to weed out some of these problems. Whereas with the death penalty, like, you can't undo any mistake, right? Because someone is executed and that is the end of the case and they're dead. So that's the conundrum there. I think on this question of what's so sort of mind-boggling about the Texas law is that when these legislators in 1973 decided on future dangerousness as the organizing principle for the Texas death penalty system, they were really grasping at straws. Basically, they were these legislators, many of them had no criminal law background, and they went to their friends, basically, who were prosecutors, the Texas District and County Attorneys Association, who were basically lobbyists for prosecutors around the state. And they said, what is important to you all? What seems to be the thing that juries rely on when they make a decision of death or life in the past? What seems to be the thing that really makes the difference to juries? And these prosecutors said to the legislators, it really seems like people have to be afraid that the person's going to kill again. Keep in mind that this is also decades before most states have even conceived of life without parole as an option for sentencing. So that means that if somebody doesn't get the death penalty, there is a chance, even a substantial chance, that they might get out of prison someday. And so the idea that they would go on to commit future crimes, I think, is particularly terrifying for people. This is also an era when the phenomenon of serial killers, I think, is a little bit more in the news media maybe than it had been. And what ends up happening is that organizing the system around future dangerousness, and this is something that other scholars have really laid out, I think, very thoughtfully. I'm thinking of Elizabeth Varkesian first and foremost. She sort of argued that the future dangerousness question allows jurors to convert every kind of evidence into evidence of future dangerousness, even things that in other courtrooms might be seen as sympathetic. So, for example, in another state, the fact that this person has a severe mental illness, is bipolar, or has schizophrenia, might be seen as mitigating. That is to say, maybe they don't deserve the death penalty because they weren't fully in control of their actions. But in Texas, seen through the lens of future dangerousness, it's, oh, this person is schizophrenic, they're not in control of themselves, they're definitely going to kill someone again. Or let's say the defendant's 17 years old. In another state, it might be he's young, he's impulsive, he is going to change his ways. But it's seen through the lens of future dangerousness. It's he is going to have so many more opportunities to commit further violent crimes, right? So the dangerousness question just kind of contorts all the evidence and kind of steers it into this lane where it helps jurors get to the death penalty as opposed to pushing them away from the death penalty.
Fascinating. I want to try to give not equal time, but some time to the fall of the death penalty part of the book. And again, getting back to how you nicely integrate individuals with the broader themes. Another person that gets prominent attention in the book is Elsa Alcala. And if you could sort of trace her career and how it starts with the rise, and over time, I think it may be fair to put her more in the fall camp, but can you discuss a little bit about Miss Alcala?
Sure. So Elsa Alcala was she has a very interesting background that I felt like I wanted to spend some time on in the book because it had thematic relevance and because it, I think, would just fascinate readers. She herself was born in Kingsville, Texas, which is a relatively, impoverished area closer to the border. She came from a Mexican-American family, and both of her parents died when she was very young, when she was, in her early teens. And in the 1970s and 80s, when she was growing up, this actually CPS, Child Protective Services, didn't seem to sort of enter the picture. And so her siblings, she and her siblings all kind of raised each other and lived together, and they had extended family members who would check in on them, but they all really just were living on the edge. And really, it is somewhat shocking that none of these family members ended up sort of in trouble with the law or psychologically. I mean, the resilience was just pretty incredible. And so Elsa comes from that background, and she joins, she works her way through undergraduate and then she decides to go to law school. She's very interested in debate and is very good at debating. And she gets a law degree and finds a job at the Harris County District Attorney's Office, which is the main office for prosecuting crimes in Houston, Texas. At the time, it's the epicenter of the death penalty, not only in Texas, but actually in the entire country. I sometimes bring up that Houston has been responsible for more executions than many entire states. It really was a hotbed of the death penalty for various reasons. Chief among them was their longtime district attorney, a man named Johnny Holmes, who just was a sort of diehard believer in the death penalty. And under his leadership and his tutelage, Elsa Alcala herself rises up in the ranks through the office. Only the most senior prosecutors handle death penalty cases, and she rises in the ranks fairly quickly and gets to the point where she is tasked with sending several men to death row. She succeeds in 2 different cases. One of them is a 17-year-old who murdered several people during a home invasion robbery. And the other case is basically a sort of ex-husband of a young woman who kills her and also one of their kids. Both horrific crimes, and it is not hard to imagine why she or anybody felt at the time like they deserved the death penalty. And in the book, we follow her efforts to get those death sentences. And then because she's such a sort of hotshot, a common career path for prosecutors who don't go on to become district attorney like Johnny Holmes is that they're elevated to become judges. And so many of the judges in Texas are former prosecutors. It's a Republican-dominated state by this point, and a note that I found very interesting about Elsa Alcala in the kind of pre-Trump era was that there was a really active effort to kind of elevate Latina leaders to high positions and kind of pave the way for them to reach statewide and maybe even national office. And you can see that Elsa was being cultivated in these circles by people like, governors George Bush and Rick Perry to be the next generation of conservative leaders in Texas and reflect the changing demographics of the state. Again, this was well before, there were debates about immigration at the time, but this was well before Trump came along and polarized that issue so aggressively. So Elsa Alcala then rises eventually to the point where she's on the highest appeals court for criminal cases in the state of Texas. It's called the Court of Criminal Appeals. Some states, most states actually, combine their civil and criminal systems in one Supreme Court in the state, but Texas and Oklahoma are somewhat unique in that they separate civil from criminal cases. So all she's doing is criminal cases at that level. And she's starting to see not just the individual death penalty cases that come through, to her to work on, but dozens and dozens at a time, because everybody who goes to death row has a lawyer who appeals their death sentence up to this court. And she starts at this level, sort of zooming out on the whole system, and she starts to feel troubled that the things that wouldn't have bothered her in any individual case, where it really seemed like the defendant was pretty awful and the crime was pretty awful and no one could question the death penalty, get troubling as you zoom out and see, as I've said before, racial disparities, when you see numerous examples of defense lawyers doing extremely poor work so that the jury never even really heard those mitigating circumstances that might have swayed them to turn away from the death penalty. She also is very concerned with the ways in which innocent people are potentially sentenced to death, primarily because of prosecutors hiding evidence and also because of very problematic forensic science that is anything but scientific. And all of that leads her to start to question the death penalty. She becomes a frequent dissenter on this extremely conservative, extremely pro-prosecution court. And that is very isolating for her, but eventually she receives vindication. And I wanted to kind of dramatize what this was like as a state level judge to get this vindication from the Supreme Court, where even conservatives on the Supreme Court say, the Texas Court of Criminal Appeals is getting this wrong, but the dissenter, Elsa Alcala, is getting it right. And this was sort of tremendously kind of a professional peak for her, right? But I think Elsa Alcala's particular journey of supporting the death penalty, seeing it as justice in individual cases, but then coming to question it and turn against it and see it as problematic, not even in the abstract as a philosophical question, but just in the practical sense of the system we have is broken. I thought that would resonate with a lot of readers and mirror the larger decline of the death penalty in the US, because I think there's a lot of people who don't spend a lot of time thinking about this system who maybe had a knee-jerk reaction to support it in the 90s, and in more recent years have come to see the racial problems, the problems related to mental illness and other things, and have come to the series of botched lethal injections that are news events, and have maybe come to question the death penalty.
Well, you mentioned several factors that likely influenced Elsa Alcala in her own personal kind of conversion or shift at any rate. And those do seem to dovetail with the broader issues. You mentioned race, innocence. Can you keep going down the list as to what,
Sure.
I mean, describe the remarkable downfall in recent years about the use of the death penalty, and what likely does account for that?
Sure. So I mean, I think a big picture aspect of this, and it's hard to write about, especially as a journalist and not a criminologist, because it's so complex, is the fact that crime really did rise through the 60s, 70s, 80s, and crime has been falling now for the last 20 or so years. And it's not precisely, on those years, but the rise and fall of the death penalty very loosely traces a rise and fall of violent crime and murder, homicide in the United States. And the relationship between those two is there's the literal relationship that, the more homicides there are, the more death penalty eligible cases there are. But I think even more important is the fact that the high crime rates created a political context in which um, um, being so-called tough on crime was seen as a real, advantage if you were running for office. And this was true at the level of prosecutors, who are, elected throughout the country, judges who are elected in many places, including Texas, but then all the way up to state legislators, governors, and even presidents. There's a famous anecdote in which Arkansas Governor Bill Clinton in 1992 flew home from the campaign trail to preside over an execution. He didn't. My understanding is that he didn't technically have to be within state lines for that man to be executed, but he wanted to be able to sort of take credit for it. It's a really horrific case, but the political moment in the 1990s was really pretty different than it is now. I think many people who read the book will remember that era or be reminded of it. Younger readers won't remember it, but the crime was a really primary issue. It was a kind of culture war issue alongside gun control or abortion as something that really got fought out on presidential debate stages, gubernatorial debate stages. And candidates were almost kind of competing with each other to be seen as tough on crime because the death penalty is simple to understand and because crime is not. I mean, the causes of crime are complex, the efforts to reduce crime are difficult, and the death penalty kind of swoops in as a very simplistic and maybe not particularly effective, but very symbolic and culturally evocative punishment. And so as crime goes down, the political temperature cools around the subject. It's not as fraught. It's not coming up as much in the national conversation. And quietly behind the scenes, lawyers like Dana and Reeser, who we described earlier, are learning how to convince juries and judges and prosecutors to forego the death penalty in individual cases. And they primarily are doing this through what we've described as mitigation evidence. And where, in the 1970s and 80s, you read a trial transcript and maybe the defense lawyer brings up the mom or the brother of the defendant to say, oh, he's a good guy, don't give him the death penalty. It's very sort of simplistic and thin kind of presentation. By the 90s in other states, and eventually Texas is a little behind but kind of catches up in the early 2000s, not in every case, but in many cases, you're starting to see these extraordinarily robust presentations of the life histories of people who have been sentenced to death. I tell the story in the book of a man named Juan Quintero who faced the death penalty, and Dana Lynn Reeser, at one point, her organization had 800 names of people who had known her client, Mr. Quintero, family members, distant cousins, classmates from elementary school, every doctor he ever went to see. And with that list of names, they do this huge investigation in Mexico, where he's from, and in Texas, where he eventually lived and committed his crime. And they build this portrait for the jury of his brain injuries as a child, the abuse he suffered at the hands of his father, his addiction to alcohol, his psychological wounds, which are severe. And all of this is not to make an argument that he should be freed on the street the next day, or even really that he is a sympathetic person, especially, but just enough to say, how about in this case, not the death penalty, right? Like, we want to extend just this much mercy to him, and he's going to go to prison with a life without parole sentence. But he's going to not get, executed. As defense lawyers are getting more successful, These cases are also costing more money. Those investigations are not cheap. Death penalty trials take a very long time, and they tie up the courthouse. And that's not such a problem in Houston or Dallas, but it is a problem in small rural towns where DAs are having to essentially ask their county leaders to raise taxes in order to pay for a death penalty trial. So, there's a rise of, as we've said, innocence cases where people are concerned that innocent people might be sentenced to death. And all these factors kind of, each influences the other. It's a kind of tangle of factors. It's hard to kind of pull one out. The last point is that, as I said before, in the 1970s, there was no concept of life without parole as an option in these cases. But as the cost grows, as the complexity of the trials grows, prosecutors want sort of sufficiently harsh alternative to the death penalty. They convince legislatures, including Texas, to pass these life without parole laws that allow more and more people to get sentenced. And at this point, many more people are sentenced to life without parole than are sentenced to death, than were really ever sentenced to death. And there's a kind of, for advocates against the death penalty, I think there's been a bit of a like devil's bargain around that, because they, have reduced the death penalty, but the trade-off has been a lot more of these extremely harsh sentences that, are not execution, but are, in a way, are like a death penalty, because you're in prison for the rest of your life and you'll never be able to get out. So all these factors combine, and I think what's so interesting about them is that they slowly bring along people like Judge Elsa Alcala. They slowly bring along legislators and politicians who don't feel the same political pressure. And they don't necessitate a moral decision about whether the death penalty is a just idea in the abstract. And, throughout all these years, Gallup and Pew and other pollsters are taking polls, and the number of people who support the death penalty it drops, but it doesn't drop that much. And it still tends to be around 50% or higher. But you don't apparently need society to turn away from the death penalty to reduce its use, because in case after case, you can just make the argument that this individual person doesn't deserve it. And if you just do that enough times over and over again, eventually there's no more cases left. And so at this point, at one time, Texas was sentencing more than 40 people to death in a year. Now it's less than 5 in any given year. That mirrors the rest of the country. So the death penalty is not about to disappear, but its use is so reduced that it's almost feeling like a kind of afterthought or relic of a different era.
Well, there's so much more to talk about from your book. Unfortunately, we can't hit everything, but
Sure.
I'll just mention a couple of areas that we didn't get to talk about in depth. There are a lot of wonderful stories that revolve around individuals in Texas that many people will recognize the names: Carla Faye Tucker, Gary Graham, Cameron Todd Willingham, Charlie Brooks, and these people and their stories all come to life in the book. The other aspect of the book that unfortunately we won't get to talk about that comes across very strongly is the widespread impact that capital cases have, not just on the defendant, not just on the victims' families, but on the execution team in prisons, on jurors, on defense lawyers, on judges and prosecutors, and on prison chaplains, and the ripple effects just keep going and going. All of these are brilliantly portrayed in the book. I'll let you go with one last question, Maurice. As we talk, it's toward the end of February, and the Virginia legislature has just enacted a repeal bill that the governor of Virginia is expected to sign, and that'll bring Virginia into the abolition camp. It's the first southern state that's gone that route. What's your guess about where this is going to lead? How significant is it that a southern state now has taken this step? And will we see a domino effect? Will Texas eventually? What do you think about this?
I do think that it's a big deal, frankly, that Virginia is on the cusp of abolishing the death penalty. As you said, it's the first southern state. It has a symbolic power because of its region, but also because it's responsible for the most executions in the country, even more than Texas, when you go all the way back to the beginning of the founding of the country, right? Texas leads the country in the era of the last 50 years with, after all the Supreme Court cases that we've discussed. But Virginia has been, I think it's where the very first execution happened in colonial America. And, we are, but I don't think that it's going to lead to a domino effect. And I say that because, there's a lot of Democrats with power in Virginia, and that might eventually be true in Texas. It's increasingly true in a state like Georgia, which just elected, 2 Democrats to the Senate, to Arizona, which has an active death penalty, but increasingly, state leaders are Democrats. I think that, there was a time when Democrats themselves were actually very supportive of the death penalty, and that has changed. The opposition to the death penalty is pretty widespread in the Democratic Party. But I don't think that you're going to see it as a priority for a lot of states unless sort of grassroots movements make it a priority. This seems to be one thing that happened in Virginia. One lawyer told me the other day that she was active as a sort of lobbyist for this bill, and she said she doesn't think it would have passed if not for the protests last summer stemming from the death of George Floyd at the hands of police in Minnesota. It sparked protests around the country, and the death penalty in that context was seen as like a very almost. From the context of the entire criminal justice system, abolishing the death penalty is sort of ultimately not that big a deal because it doesn't affect that many cases. But of course, you could see a similar story playing out in other states, but the cultural attachment to the death penalty in Texas, in the rest of the Deep South, is serious. And I think what we're less likely to see is abolition of the death penalty in the legislatures anytime soon, and more this sort of case by case ticking down of the numbers to the point where there's very few new death sentences every year, and there's almost no executions either. Already in many southern states that used to carry out lots of executions, you're seeing 1 or 2 executions a year. And many states, even like Louisiana, which used to carry out a lot of executions, are basically have a sort of unofficial moratorium. A lot of this stems from the inability to get lethal injection drugs, which is this whole other sort of force shaping this history. But you're just seeing that. One thing I've learned, and I kind of rely a lot on analysis by these 2 law professors, Jordan Steiker and Carol Steiker, is that in addition to, it takes a prosecutor in a town to get someone sentenced to death, right? To send them to death row. But then it takes a much bigger machinery involving the governor of a state, the state Supreme Court, all of these other institutional actors to actually carry out executions and make those happen. And if there's no political will at those levels, then executions just aren't going to happen. And you're seeing increasingly that there just isn't that political will, even in southern states, even in conservative states. But that's not the same thing as abolishing the death penalty. So I think we're increasingly going to see a lot of states fall into what some scholars call the sort of symbolic death penalty camp, where it's on the books, it's available. Occasionally people get sentenced to death. Very occasionally there's an execution, maybe, but more likely death row just sort of sits there, fills up, is a de facto life sentence, and no executions actually take place. I think that's where we're headed sooner than full abolition.
Well, I'll stay tuned. These issues are fascinating, complex. They're wonderfully developed and portrayed in Let the Lord Sort Them, The Rise and Fall of the Death Penalty. Maurice Chammah, thank you so much for spending your time and your wisdom with us.
Thank you so much for having me. Great to be with you.